Welcome to Audit the Audit, where we sort out the who and what and the right and wrong of police interactions. This episode covers trespassing, officer identifications, and police stations, and is brought to us by the Bay State Examiner channel. Be sure to check out the description below and give them the credit that they deserve. On September 5th, 2014, the founder of independent media source The Bay State Examiner, who we will refer to as Ms. Bay, was attending a police accountability march in Lynn, Massachusetts, when she noticed an undercover police officer following the protest in an unmarked vehicle. When Ms. Bay approached the vehicle and requested the officer's name and badge number, the officer allegedly hit her with his vehicle. On September 8th, Ms. Bay entered the back lot of the Lynn police station and captured video footage of the vehicle she was allegedly struck by. And after being kicked out of the lot by an unidentified officer, Ms. Bay entered the Lynn Police Department building to file a complaint regarding the incident.
Howdy. Sorry to bother again. Oh, hey.
Your IDs? You got the plan, right? Both yours. IDs. Pardon me? I need both your IDs.
What's the lawful reason for the request?
Because you're on private property.
I'm on private property and you get to see my...
In the back lot. You were on private property. You asked to leave. You took your time. I need your IDs. IDs?
Can I have yours?
I don't have one on me.
Oh, all right.
Well, go to the chief.
We are.
Sure.
That's what we're here for.
Yeah. Can we speak to the chief? This officer has invited us to speak with him.
You have to make an appointment with the chief.
Can you make an appointment for us with the chief?
No, that's not my job.
Okay. What is...
So you guys don't have IDs on you?
Can you please tell me who this officer is? He refuses to provide ID upon request.
Well, I think he's asking you for ID because you were trespassing around the back of our building, right?
Trespassing on public property.
The officers informed Ms. Bay that she was trespassing when she entered the back lot of the police station to find the vehicle that had been involved in the incident. There are only two entrances to the lot, and they are both posted with signage that marks the lot as a secured area with no trespassing and authorized personnel only signs. According to Section 120 of Chapter 266 of the Massachusetts General Laws, an individual commits criminal trespass when they enter or remain in or upon the buildings or improved or enclosed land of another after having been forbidden to do so by the person who has lawful control of said premises, whether directly or by notice posted thereon. In the 1969 case of Commonwealth v. Eggleston, the Supreme Judicial Court of Massachusetts determined that this statute applied to city property, holding that a building owned by a municipality is included in the phrase buildings of another, and upholding a conviction for trespassing in the office of the local draft board, despite the defendant's First Amendment claims. In reaching this conclusion, the court reasoned that, quote, the city had both a right and a duty to protect the building and its functions against any self-proclaimed need for an individual entry which could not, so far as appears, benefit the public use in any respect. The fact that all government property is not open to the public is well established by Supreme Court case law, but it also is reasonable under a common sense standard. For example, some government buildings contain offices for government employees who could not carry out their duties efficiently if the public was free to enter at any time. In the same way, not every part of a police station is open to the public. It would clearly be problematic if someone off the street could walk into an interview room while officers were interrogating a suspect, or if the public had access to secure evidence lockers. In this case, it also makes sense to limit the public's access to the police vehicles parked in the department's private lot for the protection of the vehicles and the officers driving them. Given the case law that supports trespassing convictions on government property, it seems likely that a court would agree with the officers that Ms. Bay was trespassing when she entered the parking lot, particularly because both entrances to the lot were clearly posted with no trespassing signs.
Well, it's only public property because it's posted not to be back there. That's
Where?
police property.
Signs.
What sign?
Signs out
I
there.
didn't see any signs.
I didn't see any signs
Did
either.
you show the signs?
You're welcome
What
to go
signs?
back there and take a look after.
Okay. Oh, after? I'm sorry.
Yeah.
All right.
But we need your IDs now.
I'm not interested in showing that at this
No?
I'm not. Yeah.
All right, so you guys are refusing? All right, then why don't you just leave?
Then you can go.
We want to check the...
Yeah, I was going to say, you've invited us to speak with the
Chief's
chief.
a busy guy.
Oh.
You just suggested
I don't
we
know
talk
if
to
he's-
the chief.
Well,
I don't know if he's
Yeah, but I guess
available.
apparently he's
you-
not.
I'm sorry,
He
what's...
just told you to do that, right?
No, you told us to talk to the chief.
Yeah, and you came around here and he's not coming down here.
Oh, right.
So maybe you should call him
Call the
and
chief.
make an appointment with him.
Got it.
Okay.
Okay. We can do that.
And may I have both of your names and
For
ID
the
cards?
time, it's badge 88.
Badge 88.
Badge 88?
Yep.
76.
Is that you? Oh, 76? Okay.
76. Thank you very much,
Thank you.
officer. It was not very difficult, was it?
Appreciate it.
And you're leaving, right?
Why? I'm sorry.
You're leaving?
No, I haven't made my report yet.
You made your report. The lieutenant
Well,
already
actually,
came
first
out
of
here
all,
and
I'd like
talked
to make a complaint about this gentleman here. Second of all,
What's the complaint?
your refusal to identify yourself is against the law.
Okay?
literally.
I'm sure, if you have an appointment with the chief, and you're talking to him, you'll get my information.
Well, I'm sure I will.
Here, the officers refuse to identify themselves, with Officer 76 refusing to show his ID card for a second time, and Ms. Bay claims that it is illegal for officers to refuse to identify themselves under Massachusetts law. While police officers typically do not have a legal obligation to identify themselves, Massachusetts is one of the few states that have passed such a requirement. According to Chapter 41, Section 98D of the Massachusetts General Laws, quote, "Each city or town shall issue to every full-time police officer employed by it an identification card bearing the officer's photograph and identifying information. Such identification card shall be carried on the officer's person and shall be exhibited upon lawful request for purposes of identification." While other states have not passed a similar ID card requirement, Section 830.10 of the California Penal Code states that, quote, "Any uniformed peace officer shall wear a badge, nameplate, or other device which bears clearly on its face the identification number or name of the officer." Despite the lack of statewide legislation, local laws may also require officers to identify themselves. For example, the New York City Council recently passed the Right to Know Act, which took effect in October 2018 and requires officers to provide citizens with their name, rank, command, and badge or shield number during specific interactions, such as Terry stops, even if the citizen does not request this information. Officers are also required to offer a business card that lists their name and shield number when the encounter has been completed. Many individual police departments have also instituted policies that require officers to identify themselves upon request. But it is important to bear in mind that citizens usually have no recourse beyond filing a complaint with the department if an officer violates such a policy. However, in this situation, it is clear that the officers violated Massachusetts law by refusing to carry identification cards and provide them upon a lawful request from a citizen.
But in the meantime, I'd like to make a complaint. Are you saying that I can't do that?
Not with us.
Not with you. Who do I make a complaint with?
The chief's the best guy.
The chief's the best guy.
Yeah.
Okay.
So make an appointment.
Okay.
What's up with that?
What is it that you're looking for?
Well, I found the car that hit me on Friday. I was reporting it earlier. It's out back.
Okay, and what are you doing going in private property videotaping police cars?
What private property?
The property that's parked out back there posted as no trespassing, authorized personnel only.
I didn't see that.
Well, it's posted all over the entrances to that parking lot.
Interesting.
It is interesting, but it is also posted.
Okay.
You're subject to arrest for going back into private property.
Am I being
Videotaping
arrested?
Police cars. Huh?
Am I being
I
arrested?
said you are subject to arrest
Okay.
for going out there. Now, what is it that you need?
Sergeant McDermott tells Ms. Bay that she is trespassing and creating a disturbance inside the lobby and orders her to leave, despite the fact that she still had a legitimate complaint to file against the officer who refused to identify himself, and that she informed the officers that she wanted to continue recording for news-gathering purposes. As we discussed earlier in this episode, an individual can be charged with trespassing in public buildings, including police stations. In the 2020 case of Commonwealth versus Bradley, the Pennsylvania Superior Court affirmed an individual's conviction for trespassing in a police station lobby after they refused to leave when ordered. The individual was filming in the lobby despite posted signs prohibiting filming, and refused to stop filming or leave the building when requested to do so. In upholding the trespassing conviction, the court noted that although filming of police is an activity protected by the First Amendment, the right to record the police is not absolute. Citing the 2010 Third Circuit case of Kelly versus Borough of Carlisle, the court explained that, quote, "The right to videotape police is subject to reasonable time, place, and manner restrictions, as long as they are justified without reference to the content of the regulated speech, are narrowly tailored to serve a significant governmental interest, and leave open ample alternative channels for communication of the information." In this case, the court concluded that the lobby filming ban was a reasonable time, place, and manner restriction that ensured the safety, security, and privacy of officers, informants, and victims, and prevented interference with police activity. However, while both situations involve trespassing in police department lobbies, there are some important distinctions between the two cases. First, in the Bradley case, the defendant's sole purpose in entering the building was to film, whereas Ms. Bay was attempting to file a complaint while also filming the encounter. Additionally, the Lynn Police Department did not have a no filming policy, and Ms. Bay was not asked to leave because she was filming, although she was asked to leave despite her request to stay and film. Given the factual complexity of this interaction, it is difficult to predict how a court would decide on the issues in this situation. One possible interpretation of this interaction is that Ms. Bay was asked to leave because she was requesting to file a complaint, which could constitute illegal First Amendment retaliation. However, a court could also conclude that Ms. Bay's complaint had already been sufficiently received, and that she was trespassing by refusing to leave when the officers requested that she do so. All that can be said with certainty is that Ms. Bay did not have an absolute right to film or remain in the building, and that an individual can legally be convicted for trespassing in a police station lobby under certain circumstances.
Well, I'm still trying to report that a police car drove into me, and I found it. It's literally out back.
Okay, and the supervisor, the officer in charge will be out with you when he gets a second to talk to you and get your complaint.
Well, somebody does need to tell him that that's what's going on.
Well, if he's already done that, then your complaint has been filed and documented.
There's information that he literally doesn't have because I didn't have it until right now. When I went back, I found the car. So I would like to tell him that the car is back there, that it's been repaired, even though they didn't report, I guess. Well, you know what, actually, I'm filming this for news gathering purposes at this point.
Okay, I've asked you several times, now I'm telling you, leave the police station.
Okay,
Your
that is an
business
order?
here- Yes, your
Is it
business
under
here-
threat of arrest?
Your business here is complete, your complaint has been documented, you are creating a disturbance in the front lobby of the police station. Leave the police station.
Is this under threat of arrest?
Leave the police station, yes, right now it is under threat of arrest. You are trespassing, creating a disturbance in the lobby of the police station.
You can't possibly be trespassing here. All right, in that case,
I think
I'm gonna leave
I think
on-
we're done
I
here.
think we're done.
okay. I'm gonna leave under duress, under threat of
Leave
arrest.
under whatever condition you want, as long as you leave.
Fair enough.
A few days after her experience at the police station, Ms. Bay submitted a Freedom of Information Act request to the Lynn Records Department and was met with some resistance. It is unclear whether the department ever responded to the request, but as of September 26, 2014, Ms. Bay reported on her YouTube channel that she had not received a response. In 2016, Ms. Bay stopped posting on her channel and abruptly announced that the Bay State Examiner was terminated, with no explanation. Overall, the Lynn Police Department officers get an F for violating Massachusetts law by refusing to identify themselves, kicking Ms. Bay out of the police station lobby, and for not allowing Ms. Bay to complete her original complaint or file a new complaint against the officers. While it may be possible for a court to justify some of the conduct of the officers, such as trespassing Ms. Bay from the property, that does not excuse the Lynn officers from refusing to take Ms. Bay's claims seriously and not allowing her to file a formal complaint. Ms. Bay made it abundantly clear that her business at the station was not concluded, but the officers ignored her protests and demanded that she leave the property without a shred of consideration for the gravity of Ms. Bay's claims. If a random citizen had walked into the station to file a report about being hit by an unidentified driver, it is highly unlikely that they would have been met with the same degree of callous indifference as Ms. Bay was. And there are legitimate questions to be raised about the true intentions of the officers who removed her from the station. The law should never be used as a means to discourage filing a complaint against a member of law enforcement, and trespassing Ms. Bay from the building without taking her complaint was nothing short of unprofessional and discourteous. There are serious implications associated with refusing to identify as an officer in Massachusetts, and the Lynn officers' refusal to allow Ms. Bay to file a complaint on that basis certainly appears to be retaliatory. Ultimately, Ms. Bay was not arrested or cited, but she was threatened, intimidated, and discouraged from filing a complaint, and it is difficult to justify the conduct of the Lynn officers regardless of Ms. Bay's alleged trespassing. Ms. Bay gets a B- because although she entered the private lot of the police station despite the posted signage, she remained calm and collected throughout the interaction, challenged the conduct of the officers peacefully and respectfully, and made a legitimate effort to follow the proper chain of complaint. There is little doubt that Ms. Bay was not within her rights to enter the back parking lot of the Lynn police station, and it is difficult to believe that she didn't see the signs posted at the entrances to the lot. At one point, she claims that she has a right to be there because her tax dollars fund the building, but as mentioned earlier, this is not an accurate claim according to the Supreme Court. If Ms. Bay had decided to pursue legal action against the department based on the information she gathered while trespassing, there is a good chance that her video footage would not be admitted into court because it was obtained illegally. Holding members of law enforcement accountable is no doubt mentally and emotionally taxing, and although committing minor violations in the name of the greater good can be extremely appealing, it is important to maintain a level of professionalism that supersedes the conduct of the officers in question. Being Being a victim of police misconduct is not a license to commit crimes, and building a case against corrupt officers is already difficult enough without handing them evidence against yourself. While I do commend Ms. Bay for having the tenacity and conviction to gather her own evidence against the Lynn officers, I would also caution her to remain within the bounds of the law while doing so. I highly encourage you all to give your support to the Bay State Examiner's channel. You can find a link in the description below. Let us know if there is an interaction or legal topic you would like us to discuss in the comments below. Thank you for watching, and don't forget to check out my second channel for even more police interaction content.